Public Policy and Administration, a case study on affirmative action, executive orders, and execution. Leadership is a process of interaction among leaders, followers, and the context in which they act. This is from Presidential Leadership in the Creation of the American Era, Chapter 2, page 21, by Joseph S. Nye, Jr. The visions and direction of public policy are established by the executive and legislative branches of federal, state, and local governments, but the implementation of these policies, initiatives, and laws are left to the public administrators. These administrators deal with the provisions that accompany the law. But sometimes an executive may deviate from the legislature issue policy and actions if they have the strength to act through executive orders. They can be produced by the president to create laws or to determine how existing laws should be carried out. This specific power of the President and the executive branch is provided by the U.S. Constitution in Article 2, Section 1. The executive power shall be vested in the President of the United States of America, and Article 2, Section 3. He shall take care that the laws be faithfully executed. At times, the need for action in the public interest is greater than the will of the politicians. Initiative is required, and the issue must be acted upon. Such is the case with affirmative action. The executive acted to address a known problem, well aware that the legislative action would move at a snail's pace. Once the vision was set, it was the responsibility of the public administrative structure to implement the orders. Affirmative action describes the policies that support members of a disadvantaged group that has previously suffered discrimination in such areas as education, employment, and housing. Historically, support for it is sought to achieve goals such as bridging inequalities in employment and pay, increasing access to education, promoting diversity, and redressing past wrongs, harms, or hindrances. The term affirmative action was first used in the United States by President John F. Kennedy in Executive Order 10925, according to Wikipedia. The practice of equality, exercised by the federal government through executive orders, has a long history. The first being Executive Order 8802, which was signed by President Franklin D. Roosevelt on June 25, 1941. It was the first federal action to prohibit ethnic or racial discrimination in the nation's defense industry. It established the Fair Employment Practice Committee with the intention to help African Americans and other minorities to obtain jobs in federal agencies, all unions, and all companies engaged in war-related work. The public employees of the FEPC were responsible for the implementation of this order, and part of their duties were to review all defense contracts and ensure that they included provisions barring private contractors from discrimination practices. On May 27, 1943, FDR issued Executive Order 9346. This order expanded the power of the Fair Employment Practice Committee with legal enforcement powers added. Field staffs in 12 regional offices worked with local labor and civil rights leaders to promote fair hiring practices, document and resolve cases of discrimination in the local war industries. Although the fair hiring campaign was technically voluntary, the FEPC staff used negotiations, pressure, and even appealed to the business leaders' patriotism to enforce fair employment. Both Presidents Truman and Eisenhower created committees within their administration that oversaw compliance by federal contractors and all agencies with the non-discrimination practices of Executive Order 8802. President Truman, in fact, issued Executive Order 9981 on July 26, 1948, abolishing discrimination in the United States Armed Forces. The order declared that there shall be equality of treatment and opportunity for all persons in the armed services without regard to race, color, religion, or national origin. On March 6, 1961, Executive Order 10925, requiring government contractors to take affirmative action to ensure that applicants are employed and that employees are treated during employment without regard to their race, creed, color, or national origin. The intent of this order by JFK was to affirm the government's commitment to equal opportunity for all qualified persons and to take positive action to strengthen efforts to realize true equal opportunity for all. The first implementation of the affirmative action was intended to give equal opportunities in the workforce to all U.S. citizens, not give special treatment to the discriminated. President Kennedy extended the authority of the President's Committee on Equal Employment Opportunity with Executive Order 1114 on June 22, 1963. The executive order extended the power of the enforcement and compliance with affirmative action objectives to not only contractors, but to work involving federal financial assistance. Public education was now impacted by this order. July 2, 1964. That is the date President Lyndon Johnson signed the Civil Rights Act of 1964 into law. All 10 titles of the law address the discrimination issues that the executive orders of previous presidents had been confronting individually, now collectively. The President's Equal Employment Opportunity Committee, established in 10925 Executive Order, was divided into two divisions. The Equal Employment Opportunity Commission is to combat discrimination in the private sector, while the Civil Rights Commission handles equal employment activities for the federal government. President Johnson issued two executive orders in relation to this act, 11246 on September 24, 1965, prohibiting employment discrimination by those organizations receiving federal grants and subcontracts. That now brought it to include nonprofit organizations. And 11375 was signed on October 13, 1967, which added discrimination on the account of sex to the list of discrimination. President Nixon issued Executive Order 11478 on August 8, 1969, which prohibited discrimination in the competitive services of federal civilian workforce on basis of race, color, religion, national origin, and it now included sex, handicaps, and age. This impacted the civilian employees of federal entities like the U.S. Postal Service and civilian support services for U.S. Armed Forces. Every president since the passage of the Civil Rights Act of 1964 has used executive orders to enhance and try to further define the meaning of discrimination. The latest act being Executive Order 13672, signed by President Barack Obama on July 21, 2014. This order prohibits federal contractors from discriminating based on sexual orientation or gender identity. The term affirmative action has been so diluted that it now offers evidence of reverse discrimination. Critics of affirmative action argue that it is counterproductive or should be discontinued. They argue that it hinders reconciliation. It replaces old wrongs with new wrongs, undermines the achievement of minorities, and encourages individuals to identify themselves as disadvantaged even when they're not. It may increase racial tension and benefit the more privileged people within minority groups at the expense of the least fortunate within majority groups. They argue that any effort to cure discrimination through affirmative action is wrong because, in turn, it's another form of discrimination. Another criticism is that it may reduce the incentives of both the preferred and the non-preferred to perform at their best. Beneficiaries of affirmative action may conclude that it's unnecessary to work as hard, and those who do not benefit may perceive hard work as futile. Affirmative action tends to emphasize target goals instead of quotas. This emphasis has been the cause for several lawsuits since 1964, one of the most famous being Schuette versus Coalition to Defend Affirmative Action in 2014. In a plurality opinion, the Supreme Court held that the ban on affirmative action, which was approved by the voters of Michigan in the Michigan Civil Rights Initiative Amendment to the state constitution, was constitutional. In conclusion, affirmative action is a noble goal, yet it appears the initiative's interpretation swings from one extreme to the other. In the middle are the government employees and bureaucrats that have to enact and enforce the laws of the land. Public policy, which is expressed by the hedgehogs, implemented by public administration, the foxes, will always be evolving, as will affirmative action. Public policy and public administration are two sides of the same coin. One decides, the other does. They cannot be separate because one side cannot exist without the other. But because policymaking is a continuous process, it cannot end with implementation. That is from Introducing Public Administration, Chapter 1, Defining Public Administration, page 9, Schaffertz, Russell, Borick, and Hyde.